Hello everyone, welcome to my presentation called The Utility of DOI for the Study of Serotonin Receptors. My name is Alaina Jaster. I have a PhD in Pharmacology and Toxicology from Virginia Commonwealth University, where I studied DOI for a large majority of my time in my PhD. I'm currently working with XyloBio, but this presentation is on behalf of the Students for Sensible Drug Policy Science Policy Committee, of which I am co-chair. I'm really excited to talk to you today about this topic, and for all of the relevant details that you'll see in this presentation, you can check out our review by the same name. And let's get started. The DOX compound series has a rich history, and so when I say DOX compounds, I'm referring to the phenethylamine psychedelics with chemical chemotypes derived from the parent compound mescaline. And as you can see on the slide, DOI is present, and really what makes DOI different from other DOX compounds is just this iodine on the fourth position. And so all of these different series of drugs will have a different chemical on that position. So Alexander Shulgin synthesized DOM originally, which was widely used in 1967 as a drug commonly known as serenity, tranquility, and peace. And then DOM was placed in Schedule 1 during the creation of the CSA in the 1970, the Controlled Substances Act. In 1973, DOB was also placed in Schedule 1, but in that same year, Kutz and Malicki synthesized DOI and DOC, and these were not scheduled. And around the same time, scientific inquiry began into the serotonin receptors that led to a rich history of science associated with DOI, which we'll get into. After the discovery of serotonin and its related physiological properties, a lot of science came out investigating these things. And so between 1983 and 1987, there were 15 papers using DOI, but between 1988 and 1992, there was 139. This just goes to show how DOI kind of appeared in the literature following its synthesis and its availability. And if you see here the publication numbers in the more recent years of 2024 and 2023, 2022 and 2021, we have some really high numbers due to the amount of research and interest in psychedelics and serotonin systems. Just diving into a little bit of background here, I want to go to the 1980s where the first DOI radioligands were created. And these are super important tools that have been developed to basically identify where the serotonin receptors are in the brain and body. So the first one was these radio-labeled DOIs, and they were first reported in 1984, but then a better version, 125I DOI, was developed by David Nichols and his colleagues. And this radioligand, the I-125, is used to basically identify localization of serotonin 2A and 2C receptors in several brain tissues and different experiments, and is still used to this day. And I'm not going to get into every single point here, but this slide is just to demonstrate that DOI has been used to determine the following knowledge. There's been a lot of work with drug discrimination and the role of serotonin receptors in the effects of psychedelics across different psychedelic classes. There's psychedelic-specific activation of transcription factors that's been identified using DOI versus other psychedelics, ion channel function, specific mechanisms of behavior such as head twitch, and different related behaviors to substance use disorders, anxiety-like behaviors, and cognitive flexibility. All use DOI as a first line, essentially, to understand these behaviors with a psychedelic and also to determine the role of the serotonin 2A receptor in these behaviors. It's also been used to identify synaptic plasticity in various brain regions, and it's more than just neuroscience. DOI has been used as a research tool to identify potent anti-inflammatory properties through serotonin 2A mechanisms. These have implications for diseases that affect us every day, like asthma and pulmonary fibrosis. Further, DOI has been used as a tool to understand nociception in injured and inflamed tissues, and transcriptional changes altering expression of serotonin 2A in places like the spinal cord in the dorsal root ganglia, which is heavily involved in pain and pain perception. There's a lot of utility with DOI, and if it's scheduled, then we won't be able to understand these things. The other thing about DOI and its importance in our field is it fosters collaboration. The total numbers of papers for DOI, which is an unscheduled compound, versus DOM, which is a Schedule I compound, is very stark. So DOI, as I mentioned previously, was first reported in the literature in 1973, and DOM was reported in 1967. And the number of publications between DOI and DOM is statistically significantly different. And so when we wanted to look as to whether the Schedule I status of a substance has any implications for collaborative research, we looked at DOI and DOM publications. And so what we did is we essentially tracked the number of authors per publication for all identified publications using either compound. And the median number of co-authors on publications for both compounds was 3, so pretty standard. But the difference was that DOI had 234 publications and DOM only had 108. DOI publications were found to be more associated with collaboration with higher author count papers. For example, the manuscripts using DOI, 35% of those had 5 to 10 authors, versus only 21% of manuscripts using DOM had the same number of authors. This is all to say that in our eyes, DOI and the use of an unscheduled compound fosters collaboration because of the lack of red tape necessary to work with your fellow scientists on questions that might come up. And so this brings me to talk a little bit about what is the DEA really doing, and why am I talking about this today? So the Drug Enforcement Agency in the United States proposed to place DOI and DOC in Schedule I a couple of years ago. And in 2024, our Science Policy Committee at Students for Sensible Drug Policy brought the issue to court and challenged the DEA's arcane drug laws that cause harm to human beings and medical advancement. This is the first ever hearing of its kind since the MDMA hearings in the 1980s. And here's just a brief timeline showing kind of when the DEA proposed the rule and then when we took them to court in 2024. I think my head is blocking this, but in 2025, the administrative law judge did give their decision recommending that DOI was placed in Schedule I, but no final ruling has occurred, so DOI is still unscheduled today. And part of our challenge was focusing on research harms, and so this is how the hindrance of research at any level causes unnecessary public harm. And this was a definition that was formally recognized by the DEA court and the administrative law judge. And so when we think about research harms, it's more of a harms to research through arcane policy. And I want to just give a brief refresher on the 8-factor analysis. Many people are likely aware of this if they're involved in any sort of policy or drug research. But essentially, the 8-factor analysis is what the DEA uses to determine what schedule a drug is placed in, which would be Schedule I through 5. Psychedelics, including things like DOM, as mentioned, are Schedule I, and that's largely based on a couple factors like actual or relative potential for abuse, the state of current scientific knowledge, history and pattern of abuse, significance of abuse, and risk to public health. And I'll get into our take versus the DEA's take in a moment. So this is the facts that we have determined through this court case and through our own research into both the HHS documentation, the DEA documentation, and through our own research as scientists. And so the first point is that DOI actually doesn't have any relative potential for abuse. It does not have potential for abuse. And this is found through epidemiological data that shows no evidence of DOI use in club scenes, with heavy drug users, or within national data sets. The National Forensics Lab data that the DEA uses only reported 40 total encounters in the last 20 years, and that's law enforcement encounters, not actual use. There's no reported seizures between 2019 and 2022. So this suggests that DUI is not really a public health issue, which gets into number 2. In addition to there only being law enforcement encounters and no actual documented use, there's no reported fatalities linked solely to use of DOI, and no diversion from legitimate markets, and little to no listings on the unregulated markets as well. And this was something that was specifically agreed on in court by the DEA. Lastly, number 3 and 4, DOI shares similar mechanisms as other psychedelics, and it's well studied in research settings as a tool to understand serotonergic mechanisms. One of the things that the DEA argued is that pharmacological similarity equaled abuse potential. So just because DOI is similar to LSD, which is highly used recreationally, that means that they have high abuse potential. But what they didn't talk about was that psychedelics have sporadic use patterns in humans and animal models, and they don't produce the same abuse liability as other drugs. Interestingly, despite DOI being really well studied, as I showed earlier, the DEA purposely omitted preclinical findings from the last 5 years that included work on mechanisms of substance use disorder, inflammation, and more, only highlighting research that fit their agenda. And a lot of people might ask, who cares? I already have a license. I collaborate with someone who has a license. It's not that big of a deal. But we've actually heard testimony from several folks that this does matter. It matters to new PIs trying to establish groundwork in psychedelics. It matters because there's no evidence that would lend DOI to be scheduled. And the only reason it's happening is because of the precedent that has gone unchallenged until now. So what does this mean? Essentially, nothing's actually happened yet. Business as usual, and that work with DOI can still continue on. And we'll let everyone know when that changes. In the meantime, the government has passed something called the Halt Fentanyl Act, which contained expedited processes for Schedule I registration that I think is really important for people to know. And the whole point of this Halt Fentanyl, besides making it illegal and harsher sentencing for any fentanyl-related substance, it also offered an opportunity to streamline processes related to Schedule I registration. And so many of these provisions offer opportunities to foster collaboration, reduce research barriers, and in turn research harms, but there's more work to be done. And as of January 16th, the Attorney General did not post guidelines for these new processes, which is breaking their own legal mandation and timeline. So what are these HALT provisions? So it essentially means that any qualifying research that's done through an IND with the FDA, conducted by HHS, or funded through HHS, which includes any NIH, DOD, or VA grant, all of this research can have a streamlined process to get a Schedule I license. And so if you already have a Schedule I license, but you want to add new drugs, you want to obtain an institutional license through multiple labs, you want to obtain a collaborative license with multiple locations in the same city, or even manufacture small amounts without a manufacturing license, this provision will allow you to do so. So it's really adding easier, streamlined processes for a lot of the people who are already doing the work to be under one license. And it also makes it easier if you need to manufacture small amounts of substances that would be Schedule I. Further, if you have a Schedule II license but you want a Schedule I license, there's an expedited process for this as well. And so while the application is not officially set up yet, there will be an application where you just need to send all of your documentation and your protocols to the DEA, and they will expedite your Schedule I registration. And right now, like I mentioned, the provisions and the official rules have not been published yet, and they were supposed to be published January 16th. So right now we're working on a push to get these rules, but if you're interested in trying to go this route, please let us know and we can direct you to the proper office, which would likely be the DEA Diversion Control Office. And this is just a quote from one of our Science Policy Committee members who pursued this Halt Fentanyl option while also pursuing the full Schedule I license protocol. And they never received a response regarding their Halt Fentanyl application, and the local DEA officers didn't know about it directly and were largely unfamiliar with the specifics. So just proceed carefully and let us know if you're interested in trying this route. And it's important to recognize that even though DOI is still unscheduled and will likely remain so, there are other options for the study of serotonin 2 receptors for now. It's important to note that some of these do have off-target effects, and some recent papers have come out really diving into some of those, but they do have a good nanomolar range for serotonin 2A receptors. And some of these would be TCB2. It's been studied related to synaptic plasticity and maturation. It has less than 10 publications, and it is an analog of 2CB, so could fall under the Federal Analogs Act. Another one is 25CN-NBO. This one is likely more of a attainable option. It's been really well characterized in head twitch response and locomotion across doses, and there's mechanistic studies using serotonin 2 antagonists and agonists related to 25CN-NBO. Another one, less heard of one, is LPH5, which is also high affinity for serotonin 2A and has been characterized in behavior as well. And so when we move forward, I just want to leave everybody with some of our recommendations through the SSDP Science Policy Committee. So we know that several lines of evidence exist to show that basic research has medical value, and several psychedelics being investigated have breakthrough designation. And so we really want to remove the requirement in case law that currently accepted medical use only pertains to FDA-approved substances. We also want the DA to establish an external review panel on drug scheduling because the DA and HHS reviews and they employ only a single internal expert on a drug topic, causing a bias in drug ruling. This external panel of community members and expert scientists and stakeholders would provide comprehensive review, including changes in scientific standards to evaluate substances and abuse potential. We also want to eliminate special registrations for Schedule 1 and place them all under Schedule 3. If a substance is being scientifically assessed, a scientist shouldn't have to go through all this red tape just to obtain a license to look at those substances. There's not high levels of diversion in institutions where this research takes place, and there's no reason that the research and diversion cannot be monitored with the drug in Schedule 3. And then lastly, there's an HHS appropriations rider that essentially makes it so funding being spent on any activity that promotes legalization of any drug in Schedule 1 is not allowed. And really what happens here with this kind of language is it prohibits innovation and exploration of funding to studied controlled substances in Schedule 1. How many psychedelics are in Schedule 1 right now, and because of this rider can't be developed further without some sort of formulation? And can't be funded because of this rider. It's ridiculous. So thank you guys for listening to this presentation and bearing with me here on some of the legal chat. If you want more information on all of the things I talked about today, our DOI review is scannable right there that goes over a lot of this and where the figures were adapted from. There's information about halt fentanyl in the second QR, and if you want to read our post-hearing brief from the court, you can scan that third QR right there. And I just want to give a shout out that this presentation was made possible for the International Society for Research on Psychedelics, and I presented it there this past February at the annual meeting through the help of the Hefter Research Institute travel award that I obtained. So thank you guys so much for that opportunity, and I really hope that this reaches the broader audience. A lot of people asked for my slides after too, so this is for you guys. And if you're interested in joining the Science Policy Committee, check out any of those emails or find more information on ssdp.org. And if you want to learn more about what happened in the hearing, psychedelicbrainscience.com has podcasts for free diving into all of the nitty-gritty. So thank you guys so much.